Hello all, welcome back. I hope you enjoyed lunch. This is going to be our third panel for today. My name is Garrett Crowell and I am the incoming managing editor for JBTL. For our third panel, we're going to be discussing data privacy and legal developments in the VR and AR arena. Today I have the distinct pleasure of introducing the moderator for our symposium's third panel, Professor Kevin Tu. Professor Tu is a professor here at the university. His recent research has focused on evaluating the current financial and consumer protection laws in the United States and developing a legal and regulatory regime for emerging payment systems like virtual currency. Professor Tu, of note, has been cited in the Harvard Law Review and reprinted in the Intellectual Property Law Review. Ladies and gentlemen, please join me in welcoming Professor Kevin Tu.
Well, thank you very much, and thank you for the introduction and the welcome, but it is truly my distinct pleasure to welcome our distinguished panelists for this third panel on data privacy issues inherent in the VR and AR technology. So in the interest of kind of giving ourselves enough time to really kind of understand this issue and have time for questions from the audience, I'm going to keep the introductions short. Let me assure you that the resumes and CVs of our panelists are long and very, very distinguished. So I'll start kind of at your left and move this way. Our three panelists today are first David Opderbeck, who's a professor of law and the co-director of the Gibbons Institute of Law, Science, and Technology. His work focuses on intellectual property, cybersecurity, and technology law and policy. We also have joining us today Ann McKenna, who's a professor at Penn State Law and who is also an associate faculty member with Penn State University's Institute for Cyber Sciences and a member of the ICS Coordinating Committee. Professor McKenna teaches information privacy law, cyber law, civil procedure, and evidence. And finally, our third panelist is Professor Horace Anderson, Jr., who joins us from Pace Law School. Professor Anderson has been on the faculty at Pace since 2004, and prior to that was practicing in the New York offices of White and Case, where he practiced primarily in the areas of intellectual property, privacy and data protection, the internet, and media and technology law. So with that, I'd like to welcome our first panelist, who I believe is going to be Professor Opderbeck, to begin.
All right. So there's the mouse for the... Oh, beautiful. All right, thank you. All right, so we're sort of the panel on privacy and security and those sorts of things. And I think one of the themes of my presentation here is how some of the things we've been talking about throughout the day kind of relate to some bigger social questions and really some questions ultimately about ownership and some questions about sort of the way we structure our society, the way we think of a society as our society as kind of structured as a constitutional order under law, and how perhaps VR and AR might change some of those things. So I wonder, are any of you fans of the show Black Mirror? A bunch of you, wow, almost all the students, that's great. If you're interested in this space, I mean, this is a fantastic show to watch, so you probably know this episode, which is a great intro to this whole topic. So the episode was called Nosedive, and the show, if you don't know it, is kind of an episodic show about the way new technologies in the relatively near future might affect culture and society. So this episode had to do with social media, with the way we rank each other on social media, and the way that might overlap in the broader society in an era of really strong augmented reality. And you can see on the screen here is one of the early scenes in the episode where the protagonist is getting a coffee, and she's looking at the guy who's serving the coffee, and everybody in this society basically has eye implants or contact lenses that augment your perception with the social ranking score of the person that you're looking at. So she's looking at the server, he's got his social ranking score. He's trying to do a really great job, because if he does a great job, then she'll give him 4 stars or 5 stars, and his rank will slowly go up. People are constantly doing this to each other throughout all of their interactions during the day. And your social rank is not only kind of just, it's kind of a cultural cachet or whatever, but it influences the school you can get into. It influences the apartment you can rent. And the protagonist in this episode is trying to bump her score up so she can get into a nicer apartment. So it really affects absolutely everything that you can do in the society. And as the episode goes on, she makes a bunch of sort of just stupid mistakes in her social interactions. She ends up, her ranking ends up nosediving, and she ends up just about in 0 territory and getting locked up in jail. So it's kind of a real dystopian picture of what some of these things can do. And it's, in that sense, maybe a bit unrealistic, but it causes us to think about some important themes. And, we had our panel on IP, we had our discussion of the way you can protect some of these technologies and some of these things from a business context. I think we mentioned kind of all of these different fields of IP law. One thing to think about with this, from the perspective of representing a client who's a business, we want to think about how can we help them secure those rights, or if we're in a dispute, how do we negotiate that or resolve it? From a broader social perspective, to the extent these kinds of rights exist, and to the extent we're spending a lot of time in this kind of space, whether it's a fully virtual space or whether it's an augmented space, then there's a sense in which someone else is owning, aspects of the society we live in. Now that's always true. We're sitting in this room, you don't own that desk. You probably pay enough tuition to own that desk if you're a student, right? You don't own that, things like that. But we have to think about how that's going to map onto this augmented space. So that's one piece of it. The other really fascinating piece to me, and kind of scary piece, is this overlap with privacy and this overlap with security, and in particular, as we've heard throughout the day, where is a lot of the value for the folks that are making and selling this tech? A lot of the value is in the data, right? In what they're collecting on us. We all know this from, of course, the kind of traditional social media that we all use, the Facebooks or the Instagrams or so on, that we like to use, that's free. I just saw, a news article today where, Mark Zuckerberg kind of acknowledged that pretty much everybody on Facebook, your data, Cambridge Analytica probably has it, right? And the article said, that's 2 billion people, right? 2 billion people. Your data, Cambridge Analytica has it and is using it for whatever reasons. And they presumably can because of the user agreement. So we kind of know that. We're beginning to get concerned about it. How many of you have heard this metaphor, the second half of the chessboard? Nobody. I'm surprised. All right. So this is an old sort of parable. And in this parable, this kind of guy in the village goes to the king and he says, I would like to propose something for you to give me some rice because my family is hungry. And the king is kind of intrigued and says, all right, what's your proposal? And he says, well, I don't really want much. All I want is, let's get out a chessboard. And I would like you to just put one grain of rice on the first space, 2 grains on the second space, 4 grains on the third, and just double it, right? Just every space, just double the rice. And that's all I ask. Once the chessboard is filled up, that's all the rice I'll ask for. And the king says, yeah, well, how much could that be, right? It's just a chessboard. There's a limited set of squares. But it's a logarithmic equation. So if you kind of look at the bottom of my screen, it's a little bit hidden behind the chairs. But and the king realizes that the first half of the chessboard, as you're doing this, it's kind of a number you can comprehend. But by the time you get into the second half, the numbers get so big that it's almost impossible to comprehend. And if you actually get to that last square on the chessboard, it's like 18 trillion grains of rice or some crazy number like that you wouldn't even imagine. People often speak of this in relation to computing power. So you've heard of Moore's law, and every year the power doubles, and it may or may not continue to hold, but you get to a point where if it continues to double, you get into these size of huge numbers. The same is true of the data that is collected about us and that can be collected about us. When you start to think about all the data points that already are collected in social media, then lay onto that, tracking of your eyes, of the direction of your head, of all these other things we've been talking about with AR and VR. It gets to a part of the chessboard where we can't even imagine the scope and the scale of what's being collected and how that's going to affect the way a society operates. So, I mentioned kind of the Facebook dilemma. One of the things that our panel will talk about a bit is the fact that in the US, we tend not to think of personal information that is not otherwise protected by an intellectual property right as any kind of property right, as something that you have some kind of legal ownership of. We have a few areas of law, which the panel will talk about, where the law will give you some protection, like your healthcare records or some things where we think there's a special reason. But in general, it's not because you own it, it's because we think there's some special reason behind it. And this is one of the reasons why you can just freely and easily and without even hardly knowing it contract away your presumptive privacy rights to an entity like Facebook. So all of these relationships are really being structured not by kind of a property type regime, but really by a contract type regime, and even at that, a contract regime that really isn't negotiated. It's just terms that corporations are giving us. So there's an information asymmetry. That's why I said augmented reality or asymmetric reality. As it is, some of these big providers have much more information on us than we could ever have on them. Well, I kind of have up here a picture of some Cat5 cable, what you would use to plug into a network. And the reference that I'm using to the word jack in there, if you're an old school cyber law scholar like me, you will have read William Gibson's Neuromancer, which was one of the great early kind of cyberpunk novels. And it was one of the first sort of uses of the term cyberspace. But in the Gibson novel, it's really a virtual reality kind of world. And he envisions that you're sort of in this space, but you literally jack yourself into the network. And then you're in the virtual space. So as it is now, we sort of jack into the network. If you just log into your browser, you're in the network. But we're not quite yet doing it physically. It's already really hard to unplug, isn't it? I mean, we know everybody's walking around looking at their phones. But what happens when these interfaces get closer and closer and closer to the rest of us? We can still at least kind of put the phone down, hopefully, right? Will we be able to take the goggles off? Or will it actually get to a place, which is the place where I think it's definitely going, and which is a place that I think is really interesting and concerning. Because the future of AR and VR is not in goggles that you're going to wear. It's also not even in glasses as stylish as they may eventually look. What I actually have on the screen here are drawings from a patent application that Google has filed on some of the technology that's in Google Glass in contact lenses. So the kind of heads-up display, all these things, what I showed you in that Black Mirror episode, it's not that far off. Now, it's not quite there yet, but it will get there as the computing power and all the other things you've heard of. Not only, I think, will it be wearables, but I think it will become implantables. And this is not that far off either. In the kind of cyber law space, when I teach these courses, I often talk about convergence. And I think this is one of the really important concepts to think about, because you have different kinds of media like text and video and audio and music. And we historically have consumed these things on different platforms, different devices, different ways. And the dream of media producers is to have all of that converge onto sort of a single, simple platform so that you can consume it all. That's already with us in many ways. That's your phone, right? Those phones didn't exist when I was in law school. That all exists now. The further piece of this is going to be biotechnology. And as biotechnology becomes more like computing technology, and you have synthetic biology and so on, you will see those technologies also converge. It won't just be Google Glass, it'll be, the new Google Eyes that you can buy and have put in, not just because you might have a medical condition that you might need them, but because they just make it easier for me to see all of your social media profiles floating over your head, or to see my students' grades floating over their head, or their attention span, or whatever it might be, right? So, I'll sort of leave off my presentation here, and I'll let some of the other panelists are going to fill in a number of details and other thoughts. But I would suggest that we want to still value a free and open society. Of course, from my perspective, I am a technophile. I think the technology is really interesting. I think it's going to bring great benefits. I also certainly don't begrudge a business an opportunity to earn a profit and all those sort of things. It's how many of us make our living as lawyers. That's great. Yet we just need to think about it, right? We need to be thinking about it carefully. You as students especially need to be thinking about it carefully. And how do we preserve that our society remains fundamentally a constitutional order governed by the rule of law with sort of the rest of our ordinary social norms and interactions, and not anything sort of getting closer to that technocratic dystopia where it's corporations really governing things through contract and intellectual property rights that many of us don't have control over, with the benefit of this huge amount of data that allows them to do all sorts of predictive analytics and other things underneath the hood that you might not even know are happening. So a lot of challenges, I think, challenges we can meet, but a lot of challenges that we have to think about. Thanks.
Afternoon, everybody. So I'm going to, before I start, give you a couple of book and movie recommendations, one of which you heard about this morning from Nathan. If you want to get a sense of where virtual reality might go in the relatively near future, and where AR might go in the relatively near future, I've got two recommendations. One is Ready Player One, which I haven't seen on screen yet, but which I'm going to see pretty soon. But I have read the book, so I've got a sense of the story, and I'm actually going to talk a little bit about that story as part of my presentation today. As you heard this morning in Ready Player One, life is so crappy in Earth as we have left it that people live almost their entire lives. Any part of their lives that's worth living is lived virtually. And the second recommendation has to do with AR, and that is a short story which was later made into film. The short story was by Philip K. Dick, called Minority Report. It was made into a movie starring Tom Cruise. The world we are living in this story is one where augmented reality is a reality. So for example, I can walk down the street, and if there's a Banana Republic 100 feet ahead of me, based on a scan of my retina and the fact that there is a Banana Republic 100 feet down the street, I'll get an ad, and a personal ad. Mr. Anderson, you might be interested in these deals at the Banana Republic that's just down the road. I might also, based on the fact that my retina can be scanned, be able to see, and this is part of the story of this movie, that the police are looking for me. And then all of a sudden, the fact that I'm walking around and the network knows where I am becomes a really big problem. So, as I said, not really a part of my remarks, but if you want to get a sense of how it could conceivably play out, including with implantables being the way that you experience AR as opposed to a device that you carry in your hand, check those out. And by the way, the only way you can plug out in Minority Report is an eye transplant, because, again, everything is keyed to your retina. But to get more into my specific remarks for today, you know, we've gotten used to this idea, or many of us who think about this anyway, that our personal data is a commodity. And it can have immense value to people who sell goods and services and to people who are trying to advertise to us, who are facilitating advertisement. And there's value there, and we trade on that value as consumers. I wouldn't say we get, 100 cents on the dollar necessarily, but we do trade on the value of our information because we get, in exchange for our identifying data and our preferences, our habits, our associations and affinities, our purchase patterns, we get free stuff. We get free access to apps. We get sometimes discounted goods and services. And sometimes we get premium treatment in exchange for telling people or allowing people to collect this information about us. Generally in the United States, regulation on use of our personal data has been focused on making sure that those who are using our data are clear to us in terms of how they plan to use it, and making sure that they do with it what they say they're going to do and no more, and in some places and in some situations, reporting and disclosing where there's been an occurrence of a data breach. And that's about it, at least in the US, with the exception of very specific categories of data or specific categories of data subjects. So what we essentially rely on to protect ourselves is enforcement of the terms of use that we agree to when we connect with one of these service providers who collects our data. With a little light enforcement by the FTC, but it's mainly about this contract, this adhesive contract, which we are a party to. And our major concern about our data is identity theft, right? The risk that someone is going to use our information and our identity to make purchases, to take out loans, otherwise commit fraud, all to the detriment of our financial position and our credit profile. Recently, we have now been introduced with the latest scandal connected to Facebook with this idea that use of our data for unauthorized political purposes is a pretty big deal to us as well. But that's relatively recent, and for the most part, it's been about identity theft and what that'll do to my credit rating or what that'll do to my, the amount of debt that's attached to my name. So how does VR and how does AR change our relationship to our personal data compared to our current online and social media world? Well, the immersive nature of VR, right, including attendant psychological, physiological effects, physical responses, especially when you're using so-called haptic gear, when you are connected to a VR environment, they all contribute to an experience that's very difficult not to perceive as real, right? And we heard a lot about that this morning. So as this technology spreads and improves, VR environments are going to become more attractive places for at least some of us to spend more time than we spend in our actual physical lives, right? And as I referred to earlier in the Ready Player One movie, the world is so crappy that everybody's spending all their time in the oasis. But even if we don't get that far, you could see where doing certain things will be more attractive in a virtual world than in the real world, quote unquote real world, if the virtual world feels real enough to us. Now, because it's so real and potentially so attractive, VR is going to give us a new dimension to privacy from my perspective. And that's going to go beyond the traditional Brandeis and Warren right to be let alone. It's going to even go beyond our current desire for a right to control how our data is collected and used so that we don't become victims of identity theft. VR and AR can create a desire for a right to hide behind an avatar, to keep your entire identity, personality, etc., out of the public sphere while fully participating in the public sphere at the same time. So you're not a hermit, you're just fully participating as someone other than yourself. So you're working, you're socializing, you're obtaining an education, engaging in recreational activities, all of that, but not as you, as someone completely different. So when should you be able to hide, and when should you be forced to reveal? Compared to the typical online environment that we think about now, there's going to be much more data that we might want to protect and that we might want to keep out of the public eye. So who is the live person behind a particular avatar? Not necessarily going to want that to be revealed, and I'll give you a couple of examples from Ready Player One that I think make the point. Other things that you may not want people to know. Where have you been? Where'd you go today? Where have you been looking today, right? Where has your gaze gone today? What have you been doing? Where have you been? Who have you been with? These are all things that you may not want to communicate publicly, which will be part of the data that you might want to protect in some way. Beyond that, there are going to be assets and abilities connected with your VR presence, connected with your avatar. You're going to have a virtual financial position that could be different from your actual financial position. You are going to potentially have saleable skills tied to your avatar that you might want to monetize, and that you might want to highlight rather than your given set of skills in the physical world. There's a bunch of other stuff having to do with IP, which I'm not going to get into because I think that was covered well this morning, but there's obviously creation that you can do if you're living most of your life in the virtual world, that it's going to raise all sorts of issues as to who owns what's either being produced as a result of your creativity or your innovative abilities. So now let's talk a little bit about a couple of characters from this story, Ready Player One, that is set in a dystopian future where, as we always seem to do in science fiction, humans have rendered the planet uninhabitable. And life is so difficult, as I said before, that anybody who has the means to do so immerses themselves in this giant VR multiverse, and they live there as much as possible. So the main character, and I'm showing you now images from the motion picture version of this story. Main character is Wayne Watts. He attends high school and works toward his high school diploma entirely within the Oasis. He does this and most everything else in his life as Parzival, his avatar. So on the left, you see Wayne in a car that he's living in. So I'll get to that in a moment, or actually that he spends most of his days in. And on the right, you see his avatar. And that's really the face he presents, for the most part, to the world. So he is a poor teenager, actually an orphan. He lives in a sort of futuristic, again, dystopian version of a trailer park, which you really have to sort of see either described in detail in the novel or see depicted on screen to understand, but just think about stackable but not stable trailers or mobile homes on top of each other. Now he's poor, he's a teenager, he's an orphan, he has not much family to speak of, really comes from nothing and is living in a trailer park. Despite all this, his avatar enables him to end up earning a high income, making expensive purchases in order to keep up with the Easter egg hunt that's the main part of the story, to live in a fancy apartment, and to become a celebrity without anyone knowing who he actually is or where he's actually from. And in fact, making sure that no one knows who he is or where he's from becomes critical to his personal safety in the story. Now I'm going to stop before I give you my next example, because this one is a bit more of a spoiler for anybody who is planning to read the book or the movie, so cover your ears if you don't want to get this next fact spoiled for you, because it's something that gets revealed late in the story. So this is Helen Harris. On the left, or upper left corner, is Helen Harris in real life as depicted in the movie. And her depiction tracks the description of the character in the novel. Lower right is her avatar. Now, here's what's interesting about Helen Harris and her avatar, H. She spends all of her time, just as Wayne does, in the Oasis as her avatar. You'll notice there are physical differences between Helen and her avatar. Helen has decided that in order to be successful in life, in the VR realm, she should be an identifiably male person. And actually, in the novel, she deliberately chooses to have an avatar that is a white man, so that she can avoid the discrimination and diminished opportunities that she would face as a young black woman. So again, it's very critical to her success in this world that no one knows who she actually is. So for each of these characters, the fact that they can hide behind this veil creates tremendous value. Their privacy concerns now go beyond, what we think of as a fear of identity theft, and really about a fear of identity revelation, piercing the veil of their identity. For Wayne, the difference between squalor and relative wealth is the fact that he doesn't present as a poor or orphaned teenager. For Helen, the difference between obscurity and celebrity, and maybe even the key to her survival, is the ability to lead or present with the race and gender of her choice. So, where does that leave us in terms of a legal response to this new world where I think the privacy issues might change? Well, it's got to go beyond privacy policies. It's got to probably even go beyond data protection regulations. And we might have to decide at what point and under what circumstances criminal law and procedure might allow us to pierce the identity veil. Public health law allows us to pierce that veil. Securities laws and tax laws, to the extent that avatars are creating and trading in valuable and appreciating in-game assets. As we talked about earlier, IP laws are going to increasingly have to adapt to creation and innovation that happens in these spaces. Very importantly, I think we have to decide whether our current data privacy paradigm, which allows us to freely contract away our personal information in exchange for these free access, premium treatment, is no longer the way that we want to go. Do we want people to be able to contract away their identity veils, where doing so might subject them to unlawful discrimination, financial ruin, reputational harm, or even physical peril? If they do waive such rights in a standard form agreement, should such agreements be per se unconscionable, right? And those agreements are the basis for our trading in the value of our identities under the current regime. When you raise the stakes as to what you lose or what you give up, I teach first-year contracts, so this is really top of mind for me. You start to veer into the territory of an unconscionable contract, especially if it's an adhesion contract. So do we need to force any of these agreements to be negotiated? Now that's a logistical nightmare, except, remember earlier this morning we heard that blockchain is the answer? Blockchain might be the answer, or some AI tool that allows your avatar to do, among doing a bunch of other stuff for you or on your behalf in this virtual world, to negotiate with regard to your presence online in a way that works for you, and in a way that, at least because it's negotiated, might be less likely to be unconscionable, and therefore I think generally unpalatable for us as a society. So those are some possibilities if we stick with our traditional American desire for freedom of contract freedom to contract when it comes to this data. We may, though, finally have to go the way of Europe and build in a more comprehensive and federal statutory scheme. Game on.
Is there a clicker? No. Okay. Hi, everyone. Thank you for staying to the last panel and the last person. I think we're definitely, when we were hearing some of the questions you asked the earlier panel that was discussing all of these cool technologies and how those law intersect with it, I think the three of us were chomping at the bit a little bit, right? We're ready to talk to you about the law and data. And so I want to step back for a minute, though, and just focus on why this is so important for you all as law students. Why do you have to understand this intersection of law with virtual reality and augmented reality? And it's really simple: competence. The ABA's model rules of professional responsibility require that you provide competent representation. The ABA recently amended its comments to make it clear that you are required to keep abreast of changes in the law and its practice. And so often, having practiced for decades, I would hear other lawyers say, I can't handle that. There's like online content, or there's some issue, or that's just not my space. You're in a situation now today as lawyers coming out of law school where there is not a single practice area that you will be faced with that you are not going to be expected to understand the technology, the evidence that is created, the electronically stored information that's created. So I want to step back and just for a minute, understanding the technology and why it's important. When I first got out of law school, I was given an opportunity to co-author a treatise in wiretapping and eavesdropping. Now, I was a civil litigator, and I thought, I will never use this, but it sounded like I didn't want to turn down the opportunity. And so I'm a first-year associate at Miles and Stockbridge here in Baltimore, and one of the managing partners of the firm comes down in 1995 and says, hey, we have a customer who's kind of like a precursor to AT&T. They're recording customer phone calls in Maryland. Is that a problem? I'm like, yes, that's felony wiretapping. And I'm like, I know, I'm a first-year associate. This is so cool. It was really, and I thought, wow, I thought this is interesting to learn all about the Electronic Communications Privacy Act and things that I thought I'd Stored Communications Act. I was like, it's so exciting and fascinating because as technology evolved, I was so fortunate to be in this place in my career where lawyers who I could learn so much from didn't have a basic understanding of, wow, things are changing. You all are in that space with AR and VR. And so understanding that technology and how it's used is necessary to understanding how the existing laws apply. Both of our earlier panelists today talked about some of these changes in laws. But when we think about VR and AR, we've heard a great range of things today, from Ready Player One and what could be happening. But we also had a neurologist sit and tell us how he's using VR in what he's doing to treat patients today, right here in Maryland. This is real. But it's not just for the gaming industry. You heard that. Military and police use it. It's health and precision medicine. It's happening. You saw that great presentation this morning about how they're using it at shock trauma right here in Maryland. It's used in education. It's used for training purposes. One thing we hear sometimes in this space and in the cyber law space are these concepts of precision medicine and smart and connected communities, right? And this is all about aggregating data. And one of the things with smart and connected communities, Professor Anderson gave you this great, from Minority Report. If you haven't seen the movie, it's really worth watching. Even if you don't like Tom Cruise, it's worth watching. But this idea of that we can be under surveillance wherever we go is, for anybody who lives in Baltimore, a reality. It's not a foreign concept. You live in one of the most surveilled cities in the United States of America. And it's through a combination of funding from the Department of Justice and federal law enforcement agencies that your city has cameras everywhere. And I say that having been an attorney who practiced for years in federal and state court here. It's pretty fascinating. But what's happening as we merge facial recognition technology with all of the information we're willingly giving to apps, we really are, it's a surveilled state, and we see this overlying VR and AR. So competence, though, for lawyers and for lawyers in our practice requires how the technology is being used, and then more importantly, how, what, and whose data and information your client is collecting. And when we think about it, we're talking about clients monitoring, collecting, storing, using, and disseminating. When we think about what the technology does and what are you required to do as lawyers, think back to Palmer Luckey, and we heard a lot about Palmer Luckey today. This is some kid in a garage, right? You're going to have clients who come to you like that. And when we think about VR and AR, they happen through a combination of software and hardware, right? Really simple. And I'm telling you, sitting and practicing in Baltimore, my law partner, Judge Murphy, maybe he taught some of you evidence, right? Like, people come in, and particularly older lawyers are like, we don't know what these people are talking about. It's really, you don't have a choice anymore, right? Like, this is, we as lawyers must know this. So it is very common to have someone come in who's developed this really cool mobile app. They've worked with somebody who's done a piece of hardware that they think will work with it. So you're immediately presented with a patent situation. You heard about trademarks, you heard about copyrights, but it's much more. It's for you as a lawyer. Do you understand how the hardware and software functions? You don't have to become an expert in the technology. You just have to have a grasp of how does this work and how does it interact with our law. Part of that, when we talk about this, is data. What information is collected in VR and AR? You're seeing, you're hearing, and you heard so much about headsets, but I put that aside because there's so many other ways that VR and AR happen. You know, that was a great example we all got. Look at your Lyft or your Uber app and understand what's happening there. Understand that that's augmented reality or augmented perception. The Facebook Cambridge Analytica is its own form of augmented perception, right? Because even as the Chris Wiley, the whistleblower from Cambridge Analytica who leaked the story, he described it as whispering in the ears of American voters because you didn't realize the messaging and information you were receiving was in fact altered and augmented, right? It's just a different, we look at this, it's all kinds of different labels. Also, when we talk about this, go back to the headsets for a minute. When something goes wrong, who's liable? Somebody asked a really great question, and the neurologist who on the first panel started to answer it about, well, what do you do when something goes wrong with the VR technology or the AR technology, right? So the surgeon's got the goggles on, the surgeon's following, and there's a failure. Well, you all are in law school and you've had torts, and in Maryland we have joint tortfeasor law, right? So what's going to happen? It's going to be a question of joint tortfeasor. Was it a problem with the software? Was it a problem with the hardware? Was it something that the hospital failed to maintain backups connections for power? It's really, any medical malpractice attorney is going to be faced with situations where there's an AR, VR component to that. And we have existing laws, right? There's going to be a combination of products liability and medical malpractice, and the standards of care that hospitals that are employing this technology are required to use. So that question of who is liable comes back to a lot of what you do as lawyers practicing in this area. So if you think of VR and AR, and again, you heard I teach cyber law, so maybe that's my little slant here, but I really think of this as an integrative approach. So when you think about what laws are going to govern all of these different kinds of things, you're really talking about a broad range. Regulatory agencies, Federal Trade Commission is regulating any kind of consumer device, right? If you're advertising to consumers, we've got that. We've heard a lot about the intellectual property laws, but there's data breach laws, there's biometric privacy laws, right? All of these things come into play. We have all of those electronic surveillance laws like wiretapping laws and Maryland's wiretapping laws, state and federal wiretapping laws, HIPAA. So again, what are we really talking about from the standpoint? And I think my colleagues have made this point very well. We're really talking about data, and data as the law sees it. And for the purposes of this panel, how do we address this question of data and data privacy that VR and AR create? And so you've heard data as property, right? And that's the intellectual property piece of it, of the AR software and hardware. But then there's also the individual property data piece, right? The individual's own personal data as property. And I think Professor Anderson did a great job of summarizing, in the US, we really don't value it that much the way it is in Europe. And then data and contracts. Those terms of use, all of us are clicking our little lives away on our apps when we download them and say, I agree. Data as speech, right? We think about the First Amendment and online speech. So all of these constitutional considerations that play in. This is a long checklist. I don't need to go through it, but you're going to be faced with these situations in whatever area you're practicing. And so you have to remember, who's the client? What's the business goal, right? What AR or VR is being used? What computer systems are in place? Are there existing use policies? What data does your client need? If somebody comes to you with an idea and says, I've got this great app, it's going to make a difference. It's going to save lives. How do I do that? you've got to step back and ask these questions, right? What kind of data is someone gathering through VR and AR? And that's how you're going to determine under our US system of laws, what laws do you need to know? So this is sort of just a little checklist, but who owns the data being created? We heard a lot of conversation about that, so I don't want to get too much into that piece of that. But again, it's this idea, what laws apply to what data, who can access the data once it's been gathered. And so when we talk about knowing and understanding your particular client's VR and AR uses, it's really important to remember that in the US we silo data by type. And what does that mean? We treat financial information completely protected separately under the Gramm-Leach-Bliley Act. It's very interesting because if you're not a financial institution pursuant to the terms of Gramm-Leach-Bliley, you're not bound by that. So HIPAA only applies to medical care providers and their business associates. So somebody, Facebook, is gathering your medical information, but they're not bound at all to protect your medical information or your medical privacy because they don't fall as one of the regulated providers under HIPAA. So that fact that we silo data by type in the US actually has led for a much broader evolution of corporate acquisition of data. Because all of these companies, Google, Facebook, they're not in the financial services industry and they're not in the medical healthcare industry. So they can take that information. So, but again, if you have a client, and this will happen more and more frequently, who is engaging in VR or AR that is not limited to the US borders, just remember, Europe does not. So we have, EU has their general data protection regulation, the GDPR goes into effect May 2018, just next month, and people are scrambling because any company who's doing business in any way with European citizens is bound to regulate that. So this seems overwhelming. Go back to simple questions. Knowing what the client is doing with the technology, right? Just how is the client using it? Are they the developer, right? Or are they someone who's using it and they've purchased the technology and they're using it? So do they have terms of use? If they're collecting information, are they collecting personally identifiable information from kids? And one of the professors here said, please touch upon COPPA. So I'm going to talk about the Children's Online Privacy Protection Act in a minute and how that changes things. But when we talk about does your client collect personally identifiable information, you'd be amazed that even the tiniest little mom and pop shop that has a website is collecting PII. And without even realizing it, they might be here in Baltimore and they're subject themselves to California data breach laws if they have customers in California, right? So it's this change that no lawyer who's advising small clients is used to dealing with, but you all will be able to because you were here today at this symposium. No, but so understanding the types of laws that you need to be aware of, and I'll go through just very briefly how you make this determination. You have to think about what are the client's data and information practices in VR and AR, right? And so we heard a lot about contracts and NDAs today and got that great overview at lunchtime just about how things played out when a young developer partners up with a senior person who's got an open attitude towards information, and then suddenly there's a lot of money involved, Facebook. What is interesting is that verdict, $500 million, was 25% of the sale price. It was not a small verdict, right? Understand that. Like, it's one thing to say, oh, it's less than 10% of what Facebook or what the plaintiffs asked for. Plaintiffs, you've seen plaintiffs' complaints, if anyone here has ever looked at complaints. They ask for the star, the sky, the sun, the moon, right? And the second coming. But so really, that's a significant verdict when it's a quarter of the purchase price that Facebook paid, right? And so think how much at the end of the day that if it is not reversed on appeal, how does that affect the young guy, Lucky, right? Who's the loser there? So when we think about consumer data, the collection, use, privacy, and security, the best place to start, again, is a simple question. What's the data? What is my client doing with this VR and AR technology? And are they selling a product? Do they have consumers that they are collecting their information? Well, then you have to think about FTC, right? And so FTC regulates, the Federal Trade Commission regulates data privacy and security, and they also have great website resources. So if you're faced with a case like that, go and look at the FTC's website for unfair or deceptive advertising. When we talk about collection and data and recording of customers, wiretapping laws come into play, both state and federal. We have the Stored Communications Act. VR and AR necessarily is intercepting electronic communications, right? That's part of what's occurring. through the contract process that Professor Anderson talked about. Most of you have waived away any kind of claims for that. But how are we going to really treat this? And stored communications are a little bit different. We have video voyeurism laws. It's not really clear how AR and VR are going to play out with video voyeurism laws. DC has one of the stronger video voyeurism laws, and these are things that we have to figure out. Again, if you have a client who has, say, a system's been hacked, and they're using technology that's aggregating data from customers, you have to look and say, wait, do I have medical information here? Do I have protected health information? Is it students? If the University of Maryland Law School systems were breached, well, they've got a FERPA problem, right? So they've got, so just depending upon the type of information it is, again, financial information, you're going to go through that. And whenever there's a breach, you have to determine whose information. Why? Because if it's somebody's information from a state, Maryland, you've got to look at Maryland's data breach law. If you've got DC residents whose information is breached, you got to look at all those laws. National Conference of State Legislatures has a great resource for that. So I think that this can be dry. Don't think of it as dry. Think of it, this is an opportunity where you are seeing a change in law, and you have an opportunity to bring law up to pace with how our society is changing. We heard this, all of these interesting things about like Ready Player One. We heard just how doctors now are changing what is happening in the way it's happening. And I think the question for us in the US is, how are we going to keep up with this? And it is only lawyers who are going to change these laws. The most active lobbyists in Congress are Facebook and Google. And so when the Cloud Act passes, right, who's generating how the Cloud Act, which just passed? So there's this big question about data, and when can our United States government access data that a company has in servers elsewhere? Well, Congress steps in. And so understanding the things that are going behind all of this is fascinating. We hear a lot about Facebook because of Cambridge Analytica scandal. One thing that The Verge just reported yesterday, Facebook has entered into negotiations with certain hospitals to gather anonymized medical information. So anonymized meaning they've scrubbed the patient identity, and Facebook's plan was to take the anonymized data and match it to profiles. So basically de-anonymize it, figure out whose data it is, that's yours. So if you had that, it's like, oh, she has had some depression counseling, she's on an anti-anxiety medication. We at Facebook can tell she doesn't have very many friends, or some people were making mean posts to her, so how can we do something? Could we intervene? Could we, and under the perspective of this is a holistic approach, we have more information, we can share it with a medical care provider, and we can help people. Well, is it really you want Facebook making the determination about what to do with your data? So it's just kind of very interesting how rapidly this is all changing. One quick thing with COPPA is really interesting because in this gaming industry, you heard from one of our panelists this morning who mentioned that the fan fiction website, I think that was you discussing that, Nathan, and that they're predominantly teenagers. Well, it's interesting because they would qualify as a website or an online service that collects personally identifiable information from kids under 13, possibly, right? And so what happens with that? There always has to be privacy policies in terms of use, and they have to really comply with COPPA. Again, the FTC gives very clear guidance for this, but really interesting, the changes that come into play. But this space in particular, because the gaming industry is leading the way, poses really unique information for our children. So VR and AR headsets, and I know maybe many of you here aren't thinking about, I know a 10-year-old or a 12-year-old, but when a VR or an AR is collecting your biometric data, right, so it's collecting your retinal information and it's gauging and eye tracking, that information is stored within it. It's not letting go of that data. Right? So those children can be tracked for the rest of their lives and identified at any time, anywhere. And we're all willingly just like, yeah, great, let's ride along. Right? So this is important for us to be thinking about. That's the purpose. There's also other legal risks, some of which we've touched upon, but when we think about harms to businesses and harms to customers, so we hear about data breach, we've heard about intellectual property. I already touched on this idea of products liability, right? When you have a headset that somebody talks about, yeah, there's this problem because it's causing visual disturbances, and there's people who are getting sick, that's a class action lawsuit in the making, right? If they're going to create a product that if somebody who's under the age of 13 is using it and it could cause permanent visual damage, like just these other things in there. Anyhow, but we heard a lot about harms to businesses, right? The loss of trade secrets today, loss of income, but then harm to customers. Professor Anderson touched on identity breach, but we also have these invasion of privacy torts. We have the emotional distress, we have the reputational harm, and we heard about possible physical injury today. The other piece that we don't often hear, but this is really important for you as lawyers advising clients, insurance. Whoever your client is, however they're touching this stuff, you got to make sure they're covered by a policy of insurance, right? It is critical. So if your clients are researchers and developers or in whatever piece of this, right, are their potential liabilities covered, right? So let's say they've designed a headset that is going to cause damage to someone's eyes, right? Is it covered? Is it covered by insurance? Users, right? If your client has a business that's using VR or AR technology, are the systems, the electronic systems and online operations covered? Because most, and I know insurance wants to put people to sleep, but really, most insurance policies that businesses have, commercial general liabilities and policies of insurance, have exclusionary policies for cyber activities. So you have to make sure of that. Litigators, if you are a plaintiff's attorney, is your lawsuit drafted to trigger insurance coverage? So think about these kinds of things. Is there coverage for these acts? And then ESI, electronically stored information. Virtual reality necessarily gives you are always going to be tasked with knowing and understanding electronic evidence, right? So when you have a case that involves an issue with VR or AR, identifying the problem, right? What's at issue in the case? Where's the evidence preserved? How many different people have this data, right? And how did they get their hands on the data? And when you have data breaches with this type of information, we heard today what essentially happened when Carmack left was a data breach in that Facebook case, right? It's a theft of trade secrets. So when we think about data breaches inside and out, how do we do that? And just remember, AR and VR create a trove of data. And so understanding how to get your hands on ESI, the Maryland courts, our federal courts here in Maryland, have one of the best ESI protocols in the nation. Paul Grimm, one of our federal magistrate judges in Greenbelt, is responsible for part of that drafting, and he's one of the more well-known judges in that. Make sure you understand how ESI and electronic evidence works. If you can, make sure you take courses that deal with that, that's great. That's really important. So thank you for your time.
Well, so that was fascinating, and I'm sure the audience has questions, so I'll just turn it over. If anybody has questions for our panelists, please.
Thank you very much. This kind of touches on what you were just talking about, on how products liability law and a couple of other areas of law that we've seen develop. Do you think they're equipped to handle this kind of explosion of AR and VR technologies? Obviously, the Constitution and a lot of our laws have developed over the years to like drones and things like that, and we've kind of been able to fit them in. But is this something that you think is similar and that the common law systems will adapt, or is there something much bigger, is there a much larger overhaul that you would expect need to be in place to adequately deal with it?
So I think that we're in a situation that there's not going to be some rapid overhaul change in our law. So what we have is what we have, and understanding how to use what we have is important. When we talk about, you said we've adjusted in some ways to these changes in technology. There's really inherent inconsistent recent decisions by the Supreme Court. And when I say that, so we have this Jones tracking decision, and we have the Supreme Court unanimously saying, even though Scalia made it on a property basis, unanimously saying we're uncomfortable with 24/7 tracking, right? GPS tracking, and yes, the basis for the opinion was the physical attachment of the GPS device. So it was really a trespass property-based decision. But at the same time, so we know the Supreme Court saying GPS tracking 24 hours a day, and Sotomayor and Alito's opinions, concurring opinions, really make it clear this is a problem, and do we need to revisit the reasonable expectation of privacy and third-party doctrines? Because the technology necessarily means everybody reveals to a third party. But we also have the aerial surveillance cases And they're completely inconsistent with that, because you all, if you paid attention to the news, Baltimore sits under the watchful eyes of an airplane that takes everything within a 30-mile radius. It's through a private contract with the police department here in Baltimore, paid for by a private citizen, putting the city under surveillance, a 30-square-mile radius that was not disclosed to the public. And so police could actually go back in time, and they said we weren't proactively using it, but let's say something came up where we realized, oh, there was a car accident, or somebody stole something from somewhere. So they could go back, look at the footage, and it was just two 20-year-olds sitting in a room looking at all the footage, and they were able to go back and be like, oh, here's the person, here's where they came out, here's exactly what happened. And so there really isn't a clear, comprehensive framework within which to analyze new technology and know where it's going to go. So the other thing is like the Riley case. The Supreme Court said, hey, you can't search a cell phone incident to arrest. And we're all like, thank you, right? And then at the same time, within like a calendar year, they say, oh, but a DNA swab of your mouth, that's okay, right? So think about the biometric information that is associated with the DNA swab that you could be put in. It's not just knowing your personal information, it's your extended family information, your entire genetic code. And the Supreme Court's like, we're okay with that. So it shows really a lack of understanding of the technology, because biometric information is so invasive, right, to permit the collection of that. So I think we don't have a good fit, but I think realistically, we're stuck with what we have. I don't see I mean, maybe Cambridge Analytica, the situation would require some changes in regulation, but even then, everyone seems to be freaked out at, we're not going to regulate Facebook and Google. And since they have more lobbyists in Congress, it's probably unlikely that we will regulate Facebook and Google. So I think that's what's so important, and what I would say is really interesting, even if it seems overwhelming to you when you're first practicing law, this is a space where it's really cool, because there's not many areas of law that you have to think about. Contracts, property, electronic surveillance law, biometrics. Like there's so many areas of law coming into play here. Invasion of privacy, all the privacy torts, and it makes it for constantly learning. Like I can't remember, you were like just learning. It's so, you get to learn all the time, and it's never boring. And whether it's you have someone coming in who says, there's content on me online and it's altered, it's a picture of me that's not true, and then it's been photoshopped or something, but it's also something I don't want out there. Like, you have to think about, well, that's a copyright issue, it's an invasion of privacy issue. It's pretty
as if I can jump in on that product liability question, because I've thought about this a lot in the kind of existing cybersecurity space. And so how many of you remember the hand balancing test? Nobody from your torts class? One or two? Okay, good. You're all going to have to relearn it, right?
I don't know.
So, how many of you had torts? Good. So you should all know this, right? So the one of the ways of deciding whether there's been negligence is just to kind of make a rough balance. So what's the probability of loss, P? What's the extent of the loss, L? That's one side of the equation, right? And on the other side, what's the burden of taking some kind of precautionary measure? So like, if one of the old cases, if a ship's gonna break off from the harbor and float around and bang around other ships, and you could prevent some of the damage through a $10 radio, you gotta get the radio, right? Well, in cyber security, this is almost impossible, I think, because the probability of loss is 1. You are going to suffer data loss. You cannot absolutely prevent it. The scope of the loss could be really enormous. I mean, it could be millions of pieces of data. The burden of compliance, well, there are certain steps that are pretty easy, but they don't do much because probably. So the only way to have perfect security is to just totally cut yourself off from the internet, and even then you're not going to have perfect security. So I think it really challenges some of those traditional paradigms, and there it kind of suggests maybe there's other regulatory frameworks that need to step in. So maybe there's only a certain amount of the lifting that tort law can do, and some of it has to be other kinds of regulatory frameworks.
Like a privacy officer.
Privacy officer, or on the tort and product liability side, maybe it's just fines and penalties, or really the model that is in play now is kind of voluntary private-public cooperation with government and industry working together to come up with best practices. And that's kind of really a rough way of doing the hand balancing test in a way. But I think you really have to see it more as kind of standard-based regulation. And then that insurance piece becomes important because the insurance underwriters are then going to look at, well, are you adopting what we think of at least our best practices? And that's how the risk gets spread.
Other questions?
Thank you. So I have a couple friends of mine that are in the cybersecurity and data protection industries. Something that they've really brought to my attention was this European protection statute that's being created within the European Union. One of their main arguments of concern is that this kind of, in a way, boxes out middle mom and pop shops, middle America, where they don't have the ability to get representation or understand these rules and regulations. Is there a middle ground for this? What would you guys suggest for these individuals that, we all know that IBM will be able to still trade and do business with Europe. They have the staff and capabilities here. But people that are even just selling from Kansas or something, selling, things on the internet to Europe and making business out of it, they now can't do that.
Right. So, were you going to say something?
I'll let me start. Yeah, I think part of the reason that we have generally not followed the European approach is because of the burden of tracking all the data you collect and really asking more affirmatively for permission to use it than we have traditionally done in the United States, right? So keeping track of where it goes, being more, again, asking more affirmatively for opt-ins to use the data, and then being very strict about how it's used, that's not easy to do, right? And the fewer resources you're working with, the less likely you can do it successfully, right? So in order to stay in business, you're taking on enormous risk. So so we've been talking about, right, the sort of alternatives to comprehensive regulation, and because we're talking about taking on business risk, use of the insurance industry as a component, standards as a component, and then, although I think we're still pretty far from being able to do it, as I said in my remarks, focusing on real contracts, like real agreements in terms of how data is going to be used, where some thought is put into the risk on both the data users end and the risk on the data subjects end, the individual, the consumer. So I don't think we're going to get something comprehensive and Euro-like anytime soon. I'm from the intellectual property world primarily, and in terms of the Copyright Act, if Disney doesn't want it, it doesn't happen. If Disney wants it, it happens. And I think Facebook and Google are now in that position when it comes to this space. So I don't see comprehensive regulatory reform. I think we're going to have to piece it together. The insurance industry and the FTC and the private sector, including the middle market and small businesses, and consumer advocates are going to have to piece together something that works for the U.S., because I don't think what works for Europe is going to be implementable in the U.S. Not that it couldn't work, but the reality of it happening, I think, is slim.
I also would say that the big difference tends to be just this perception of privacy and property, that your individual data is your property, is so much stronger in the EU. And it's ironic because with Warren and Brandeis, we're the society that invented the modern concept of privacy, right? Like, we put all this together, this comes out in 1890, we have these privacy torts, and the Europeans in some ways were like, what are they talking about? But we had this very unique historical background that gave us this idea of individualism, and yet the Europeans are so much more willing to say your personal data is your property. And we're not gonna let the contract just take that away, right? And so the other piece of it, though, that some commentators have pointed out, this idea of the right to be forgotten, which the EU has legislatively mandated for all of its member states, for individuals, has actually necessitated in businesses, even small businesses, having to maintain an ability to put all their hands on all of your data in one place. Because if you say, I want to be forgotten, they have to know all their pieces of it. So they've actually become much more organized in their data collection and focus on individuals, and in a way that might be, in fact, more invasive of privacy. So again, this isn't to be the doomsdayer. I don't see a comprehensive legislative reform coming out of our Congress. The only, would be, is there enough of an electoral outcry after Facebook, Cambridge Analytica incident, to force some type of regulation of this that would really merge into, because we know that Facebook is aggressively moving in the VR and AR space. And so they've introduced Portal. That's going to be Portal is a screen you'll have in your home that has facial recognition scan qualities, and will link up anybody who comes in. It will identify who they are and link all their social media accounts together. It's audio, video conferencing, and they want that to be in everyone's home. It's their way to compete with Alexa and Echo, right? Those in-home devices, right? But they want it to be the full panoply so that they can actually have an AR interaction with you, and you can game right there on Portal. So again, I don't see. Do you see comprehensive?
No, I mean I agree with these comments about the political economy of all this, and I also agree that in the near term it's going to be contractual and insurer driven and sort of soft regulation driven. I think that's right. I'm not a fan of the right to be forgotten for other reasons. I think that's an interesting one. I also think it limits the freedom of the press and some other things that I think are a real problem. But I also am a bit skeptical of the argument of small business saying, we just can't possibly comply. And how does the average small business do e-commerce today? How do they do distribution? How do they do marketing? Mostly they don't do it themselves. They do it through Amazon. Where they host the data, they host it with Amazon. Who fulfills the orders? Amazon. So there are middle suppliers who have the ability to do this and provide the market. It actually creates a market in a way. So I think the same could be true with storing personal information and making sure it's compliant. It's a cost, there's no doubt about it. But I'm a little skeptical of the idea that small businesses can't possibly physically comply.
So I think we're running a little bit over, but I'm going to invoke moderator privilege and have one more question to kind of wrap us up.
Keep you arguing. So I'm a bit conflicted when it comes to all this, because while I appreciate and like advancing technologies, it's a bit concerning that the millennial generation is going to be the last one to remember what it's like to be not dependent on technology and not have everyone be taking your data at every turn. So I'm just wondering why it's taking so long to get this under control. We're kind of witnessing this all.
It's because of you lazy millennials.
No, it's because of money.
The money?
It's money.
It just seems like we're watching this all get out of hand.
It's like watching the train crash and you can't stop it.
And the industry's not really regulating, and there's a ton of externalities I think that they just aren't correcting.
I'm very cynical, but that's probably because I'm a litigator. But it's money. Your data is money. And unless we figure out a way for you to harness the power of your data, the industry flip side is we're giving you all these services. We let you stay in touch with everybody on Facebook and Snapchat and Instagram, and you don't have to pay for it.
Yeah, and let's be honest, the service is valuable. I mean, I checked Facebook about 15 times today already, and had 2 side conversations with people, and yeah, I did. Right? I posted, to my Twitter account that I'm here at this conference, and I put on my blog, thecybersecurity.lawyer.com,
Advertising.
some stuff about being at the conference. So the services are really valuable. So it's not like we're not getting value, and I don't.
Now I'm going to have them take a picture of us so I can tweet it too.
Exactly right. So I'm not sure that it's. In a way, it's good that some of the Cambridge Analytica and these other things are coming to light now, because now we as lawyers can start to think about, how we manage it and how we deal with it. We have all these political economy things that make it really difficult. but not impossible. And it's always been the challenge.
All right,
Yeah,
how about all of you wave? Come on, let's do it. Ready? Everybody put it up. Pick those arms up there. Woo! Maryland law students. All right.
So
You just gave up your privacy, but that's
Yeah,
okay.
I know.
I would just add that
I'm going to sell it to Facebook.
I would just add to the other answers that there really is a microeconomic phenomenon at play here that doesn't start with your generation, but I think starts with mine. When I think back to the beginning of e-commerce, where there's information that's really valuable to the service provider, but in the moment when I was first starting to click yes or click accept, the difference between being able to find and buy something on Amazon versus not being able to buy it at all was hugely valuable. And so I think it really was the Generation Xers who were there at the beginning of the use of terms of use and the rise of e-commerce, finding it so much easier to do all these things that took a lot to do, right? Finding the right thing, right, that wasn't available in the store right down the street, or getting in contact with somebody. I was talking with someone yesterday about the difference between trying to call somebody whose number you didn't have and the way that telephone directories used to be organized and having to call 411 in order to find a number that was yeah, I know, you have no idea, but it was very difficult. And it was so much easier to just say yes and have access to all these things that made your life easier. And I think the succeeding generations have just grown up with all of that and expected it, but we were the ones, I'll take that burden on us, who made it easy for the data collectors to continue collecting data because it was so attractive, transaction by transaction, to do so. So I think that's why we're where we are today, and it's a very easy place to get comfortable in, and that's why we haven't figured our way out of it yet.
Well, please join me in thanking our panelists.
Thank you all.
Thank you.
So I've been asked just to share a few concluding remarks with you this afternoon. I know it's late. Mostly what I want to say is a big thank you. Thank you to the Journal of Business and Technology Law for hosting this event. Thanks, Ashley, for all of your hard work. She started working on this probably, 6 months ago, and has been hard at it ever since then. Thank you, Gita, for all of your work in getting our speakers here and getting them comfortable and everything else that you did. It's been a tremendous day. Think of all the things that we've learned. I made some notes. It's late. I'm not going to share them with you. But I think the bottom line is Professor Varshney, our first speaker this morning, ended his presentation by saying there are exciting times ahead. I think that's very true, and it's a great place to end the afternoon. So thanks for coming out.